Hello. The Divine Code reading for April 15th, pages 625 and 626. We are beginning a new chapter, The Laws of Saving Oneself or One's Own Property or One's Property at the expense of another's money and taking the law into one's own hands. So the major question, at least the first half of this, the major question is, would a person be permitted to use another person's property, another person's money, or another person's objects for their benefit or to help another person? Under what circumstances and what are the rules involved with that? And can a person just decide these things on their own, taking the law in their own hands? To what extent can a person decide to do these things? Supposedly, when the conditions are not easy to have a court, you can't have a court of law in an emergency situation. And so, what do we do in an impromptu situation where we don't have a chance at the time to go to a court of law? Topic number one: one who finds himself in mortal danger may save himself by taking another's money. This is not transgressing the prohibition of theft, since the prohibition of theft is pushed aside for saving a human life. So the saving a life, and this is a major ideal within Torah law. Saving a life pushes aside just about everything, and in Jewish law, that would be except in the cases of murder. We can't save a person's life by killing someone else, or in the case of idolatry, we cannot the Jew would not be allowed to commit adultery to save his own life. And in the case of forbidden relations, he cannot have forbidden relations to save his own life. For a non-Jew, the forbidden relations and the idolatry would be permitted, although it's not necessarily required. But to save one's own life, it might be required to save another person's life, maybe. But it's permitted, except for murder, in which case we would say that one person's life cannot be said to be more valuable than another person's life. The idiom is, how can I say that my blood is more red than the other person's blood? So in the case of murder, non-Jews would not be permitted, as well as nobody's permitted to kill someone to save another person's life, unless it's in the case of a pursuer, where you're doing it in self-defense or defending the other person. But otherwise, we're not permitted to do that. So we're not permitted to take money from another person to except in the case of saving a life or to save a serious injury, which will be discussed later. Nevertheless, he should not take another's money or belongings unless he plans to return the full value when he is able to do so. So it's not so much that we're stealing the money to save someone's life. If we need money for some scenario, we need money to save someone's life or to save our own life. We can take the money as we're borrowing the money, which normally if you borrow something without permission, that's considered like stealing. But in this case, the borrowing without permission is permitted because it's because of the situation. But we have to intend to return the money or to return the object. See Shulchan Aruch Kosher Mishpat, chapter 359, and Koshan Shlomo on Koshan Mishpat there. That's a commentary on Koshan Mishpat, chapter 359. That is the reason Raquel or Rachel stole her father Laban's idols. This is out of the Bible in the book of Genesis. since he would have used them for sorcery to divine a way that the family had escaped. So basically, it was a hope to prevent a dangerous situation for the family. Um, Laban would have, possibly by killing Jacob, would have tried to prevent the family from leaving. And that for that reason, Rachel had permission, would have had allowance, and it's a heter. It's not that there is no prohibition. There is a prohibition, but it's a heter for the prohibition. It's an allowance for the prohibition. See part 4, chapter 6, that a Gentile is not obligated to give up his life for the 7 Noahide laws except for murder, even in the case of severe illness, which the same applies to theft. So it's only the case of a death of a person or the threat of serious injury that it would be permitted to kill the other person, kill the pursuer, or borrow money, or which would be considered theft. But it's it's an allowance to borrow money or an object to save a life, or to prevent serious bodily injury. This means that saving life overrides the prohibition of theft, but does not take away the obligation to compensate the owner. So the criminal aspect of theft is put aside. It's still theft, but it's not a criminal aspect of theft. It would be more in the category of someone who inadvertently obtains an object that was stolen. He still has to reimburse. He still has to give it back to the owner, or if he used the item, he has to. It's similar to that. It's like if a person inherits, or if they mistakenly, inadvertently receive a stolen object, they have to return the object, or if the object was damaged, they have to reimburse for the damages. So the same rules were applying here. However, if he knows that there is no possibility he'll be able to pay back, he is still allowed to save himself through the other's money, since the whole reason for the obligation to pay back is the prohibition to steal. Once this prohibition is overridden by the obligation to save life, the only reason for the obligation is to pay back. The only reason for the obligation to pay back is his ability to do so. So if he, okay, the intention is to pay it back. If he knows he's not going to be able to pay it back, it's outside of his means, and even still, he has the obligation to pay it back, but he's not able to pay it back. Therefore, he wouldn't be able to pay it back. But he still has the obligation. He takes upon himself the obligation to pay it back, even if he can't. If circumstances allow him to, then he needs to pay it back. If it doesn't allow him to, then he still needs to pay it back. But he's allowed. It's still necessary to use the money or the object to save a life. Then you use the money or object to save a life. You don't worry about the ability to pay it back. That's to be figured out later. This is apparently based on the logic of the ruling of Shulchan Aruch, Kosher Mishpat 359. It is also written by Sidi Kemed on Kliam Alpha, chapter 16, Piat Hadash there, chapter 19. Although he says there that one should not take without intention to pay back, it is clear that if it would be impossible to pay back, the person would still be allowed to steal to save a life. This is also clear from the response of Samak Tzedek Kosher Mishpat, chapters 46 and 47, and Marasham, volume 5, chapter 54. So basically, it's you worry about the person takes on the obligation to pay it back when they use the other person's property. The ability to pay it back is figured out later. You kind of you worry about the billing after the fact. The person goes to the hospital because they need the life-saving operation, and then later on you figure out the billing. If, however, one is not in mortal danger, but instead has pain or disease and wants to take another person's money in order to save himself from pain, it is forbidden to do so, even with intent to compensate. So you got to go on the pain meter. I mean, on what level of pain are we talking about here? If it's an intense pain where the person might take his own life instead of dealing with the pain, then that's where we got to look into it and try to figure out, okay, at what level do we consider a disease to be life-threatening? And we can probably look at the Jewish laws of Shabbos as a gauge. To violate Shabbos is a death penalty in the Jewish law, even though it's not enacted as such today because we don't have a proper court system. But if there was a proper court system, violation of Shabbos, a Torah violation of Shabbos would be considered a death penalty, a capital crime according to biblical law. The same as theft is also considered a biblical crime according to it's considered a capital crime according to biblical law, and would not. We don't do it today because we don't have a proper biblical court to enforce the laws. Okay, so we have similar situations here where if on Shabbos, on the Jewish Shabbos, someone's life is in danger or there's an extreme duress where it's okay to violate a biblical prohibition, a capital crime biblical prohibition is okay to violate that in order to help the person. Now we have a well thought through halakha concerning the laws of Shabbos. We could look at those for examples of what would work in this situation. How do we gauge between mortal danger versus distress from a disease? At what point do we consider it appropriate to break the capital sin, the Torah capital sin, and rather it's important to help the person? I'm suggesting that could be used as a gauge that we could use here in this case. Likewise, to save oneself from an oppressor who wishes to cause pain that is not life-threatening. It is permitted to use, if it is not permitted to use another person's money. So the government is going to throw a person in jail if they don't pay their taxes. And is it permitted to take the neighbor's money without their permission to pay the taxes? And this would be considered not appropriate to do so. Surely it is forbidden to save one's own money through taking another person's money. And the Shokanor Karab laws of robbery, topic 2. It seems that a Gentile should be liable for capital punishment by a court if he steals money to save himself from pain. Nevertheless, it may be that he is exempt from punishment since the pain or other duress that is forcing him to steal. Okay, so in the earlier case where a person is under duress and their mind is not working properly, either they're under duress because of the situation or they have physical pain and their mind is not working correctly, if the person is compelled to theft in order to alleviate their duress or the pain, it might be allowed in the court. It might give him a defense in the court that he was under duress and he wasn't able to operate in a rational manner, and that he would be like temporary insanity. He would be exempt from punishment by a court. But it's still not permitted. It's just that he would be exempt because of the situation. And concerning using let's say a person hawked an item at a pawn shop. The item is worth $100, and he got $30 from the pawn shop, and he's supposed to redeem his $100 item with $30 that he doesn't have. And so he takes $30 from his neighbor without his neighbor's permission to redeem his $100 item. That would not be permitted. We're not permitted to do something as trivial as that. Even if it's a $1,000 item and he needs $30 to save it, he's not allowed to just take his neighbor's $30 unless he has permission. Then then it's allowed. Or if there's a friendship with his neighbor where that kind of thing would be allowed. It depends on the circumstance, but the basic is it would not be permitted. Topic number 2. It appears that it is even permitted to take another person's money to save one's own limb. See Shokunor Karab, Laws of Monetary Damage, topic 10. It is permissible if there is danger to limb, to limb or to life. It appears to be the opinion of Shak Uradea 157.3 that if a Jew is in danger of losing his limb, he may transgress any prohibition in order to save it, other than idol worship, incest, adultery, and murder, which a Jew may not transgress even on pain of death. So, again, it's the parallel between the two, that the allowance is given in the Jewish law, and in a parallel reading in the Jewish law is he's permitted to save his life. He's also permitted to save his limb. So that would be like a major medical thing if he's losing a limb, and that would be it'd be similar to losing his life. Therefore, to save his limb, he is permitted, or to save his neighbor's limb, he would be permitted to take another person's money or object. Topic number 3. It is also permissible for a third party, that is an onlooker, such as an onlooker, to save another's life or limb by using another's property, and this is not considered stealing. Now, within the Jewish law, the onlooker is considered a fellow, and in that term, because all the Jews are considered to be each other's neighbor, it's like one big family, and so there's an obligation to help the other person. In the non-Jewish law, it's still like an obligation, but it's an intellectual obligation. It's not a biblical obligation. We're still required to help each other, but that's because we are trying to make a better society. But we're not biblically obligated to help. But because we have a moral, logical obligation to help other people, we would be permitted to, just as we're permitted in cases to take property to another person's property to help ourselves, we would also be permitted in these same situations for life and limb to help another person by taking someone's property. The rules would still apply. See Korban Netanyahu, Bava Kama. It says 612. I would assume that's 612 within the Korban Netanyahu, based on Rosh there, that otherwise people would be hesitant to save other people. So that goes into the whole making a better society, which is the obligation that established course of law is to make a better society, and we would not be willing to help people, but by taking, we would not be willing to take property to help a person if we thought we were going to wind up going to jail for it. It's the Good Samaritan law, to use a Goyish expression. It is logical the same applies to Gentiles. Igrit Moshe Koshen Mishpat, Volume 2, Chapter 63, states that this only applies to one who damages other people's money. But if one were to borrow to save another person, he is obligated to repay. So I'm not exactly sure what it means to damage another person's money. But apparently the rules are similar, that there's an obligation to repay if we use the other person's money. If we take the other person's money and use it, we have an obligation to repay the person, whether it's to save ourselves or to save the third person. But we first take it, save the life or limb, and then afterwards figure out the how to make things correct. Monetarily how to make things correct. That's a secondary concern that's done afterwards. It is unclear if the same law applies if the person whose money he is taking or damaging is present. Do we say now? This is a theory. I mean, it could become a real question, but it's basically a theoretical question that we're looking at to try to understand this more deeply. To try to understand how this halakha works. It's confusing that we can sin by taking one person's thing, not ourselves. It takes one person's object or money to save another person. How is it we're allowed to do that? It is unclear if the same law applies if the person whose money we are taking is present or damaging is present. Do we say that the person coming to steal in order to save himself is considered a pursuer in the mind of the victim of the theft? So the person's in a state of panic. He rushes into someone. He rushes into the pharmacy, and he knows he needs a certain medicine. He's in a total panic mode at this point. He jumps over the counter and starts going through trying to get the medicine. Or he's taking money from a person in order to buy the medicine. So he looks like he's behaving completely like a thief. Can that person who is behaving like a thief, even if it's to save himself or save another person, is that person like a pursuer, a robber, who's considered a pursuer that might be a threat to the person that he's taking it from? Who will fight to the death for his money, and when it comes down to the thief saving his life through that of another, which is obviously forbidden. So now it's no longer, now it's not a question of theft. If the person is standing there, then it becomes a question of robbery, and the victim of the robbery, the person that is the money's being taken from, or the object is being taken from, it becomes a question. It goes into the issue of pursuer, which means that he could save his life. The victim of the thief feels that his life is in danger by the robber, who's taken the money to save someone else, to save his life, because he needs to buy medicine. And the victim of the robbery, who's having his money taken away from him, might feel that his life is in danger, and therefore does he have the permission to kill the robber? And if the robber is if his life is being threatened by the victim of the robbery, does the robber have permission to defend himself? So it becomes a very, one thing leads to another in this case. It's all intertwined. It's part of a chain of events. Rabbi Zalman Nehemiah Goldberg comments, does not follow the law of the pursuer. For a Jew, it would not apply, since the second person is obligated to give up his money to save the thief, who is therefore rightly taking the money. So within the Jewish law, every Jew has an obligation to help every other Jew. That's within the Jewish law, not necessarily Gentile law, but within Jewish law, every Jew has an obligation, a Torah obligation, to help the other Jew. It's part of the mitzvahs. We don't have that mitzvah. We have for us, it's an intellectual obligation. Although a Gentile is not obligated to give money to save another person, stealing is nevertheless permitted to save a life. Thus, if the victim of the theft thwarts one who comes to steal to save a life, he would be doing so illegally. The difficulty with this exclamation is that, okay, if the victim of the theft, he's having his money taken in order to save the robber's life or to save another person's life, first of all, does he know that that's the case? All he knows is that some crazed person is grabbing his wallet and is trying to take it away. And the assumption is the crazed person will, if he doesn't get the wallet, is going to threaten the person's life. That's the assumption. That's what normally the case is. If someone's trying to take a person's wallet, you assume the person is threatening their life if they try to defend themselves. So, first of all, the person would have to know that that's what's happening. The person says, "I need life-saving medicine, and I need to take your money in order to save a life." If the person is aware of that, then it might be considered. This is a touchy area. First of all, the victim would have to know that that's what's happening. And if he defends himself, defends his wallet, and supposedly defends his life, because the idea of robber, the assumption is the robber is threatening the victim of robbery's life. And so would the person be able to protect his life? Would the victim be able to protect his life by killing the robber? And according to this, he would not be, because he should have compassion on the person. I would suggest that this is still up in the air. This would make a difficult situation, and it needs to be explored more fully, because the Jewish law is that there's an obligation to help the fellow Jew. The Noahide, the non-Jewish law is, it's an intellectual obligation, and I'm not. It needs to be gone into more deeply. Topic number 4. It is also permitted for a person to borrow without permission, which is okay. So now we're talking about an object, I would assume. So before we're talking about money, now we're going to talk about an object that the person has permission to take the object. And the assumption is, just like the money is considered a borrowing without permission, this would also be considered a borrowing without permission to take an object, that they need the object to save someone's life. There's a boulder that is crushing someone, and you need a board to pry the boulder off the person, and it's permissible to take the board to save the person's life or to save their limb. They're borrowing the board, and the understanding of the person taking it is that they're borrowing it. They're not taking it forever. They're borrowing, or unless it gets damaged. But the assumption is they're not taking it for themselves, or they're using it without permission. An act normally deemed as theft. So normally, if a person takes something without permission, that even if they're borrowing it, that's still considered theft. Now, in this case, it would normally be considered theft in order to save his life. This is an item that would if this is an item normally rented, one must pay back the amount usually required for rented use. And this is the same as the laws of theft. If a person takes something that's, this was discussed earlier in the second chapter, topic number 30. So it's the same as if the person stole the object. and it was an object that was was a rental item, an item usually rented, he has to pay the rental value of the item. Otherwise, he has to pay the damages to the item. Therefore, if one stole a rental car, there'd be an example, rental car, in order to save a person's life, he must pay the amount of the rental fee for the length of time he takes it. So he goes into the Hertz rent-a-car area and he just grabs a car because he's in a hurry. He doesn't want to fill out the paperwork. He doesn't have his credit card with him, so he just runs and grabs a car and drives off with it. And the guy inside is freaking out, but what's he going to do? He has to pay the rental fee, whatever the rental fee is for that car. Whatever the rules are normally for that car, he has to reimburse for it. And he has to explain to the court that he needed it to save a life. He wasn't using it to go grocery shopping. If it is not a rental car or a rental object, so this would be like just a regular object. It could be a car, it could be anything. He is not obligated to pay any rental fee for its use, but he must pay for the replace to replace the object. Like in the case of a car, he would have to replace the wear and tear on the car, or he has to replace the gasoline. He has to return it in the similar condition or reimburse for the similar condition when he returns it. And if he uses the board, but the board, they get the guy's leg out of from underneath this boulder, but in the process the board cracks. He'd have to pay for the damages done to the board or whatever it is. If he's driving the car and he gets into an accident, he has to pay the damages done to whatever object he was using. Thank you.